Good afternoon, ladies and gentlemen. Good morning in the States, and a warm welcome to our stock-taking event on the efforts to restore judicial independence in Poland. My name is Daniel Hegedűs. I lead the Central Europe programming of the German Marshall Fund, and I am thrilled that we can have such a stellar panel today with Deputy Minister Dariusz Mazur, Judge Monika Frąckowiak from the Iustitia Association, Małgorzata Szuleka from the Helsinki Foundation for Human Rights, and Anna Wojcik, visiting fellow at the German Marshall Fund. GMF is committed to support democratic security and resilience building, and also to support the fight against autocratization through policy and legal analysis, practical democracy and civil society support, and also through convening and advocacy. And I think barely any country has played such a pivotal role in the fight against illiberal and authoritarian tendencies over the past year than Poland has. Just as in 1989, Poland pioneered democratic transformation in Central and Eastern Europe, now we see the country once again in a pioneer role in fighting its way out from illiberal state capture and demonstrating that there is a way back from illiberalism to liberal constitutionalism and pluralist democracy. I am sure that the lessons learned from the Polish experiences will strengthen the toolkit of democrats throughout Europe and perhaps also at global scale. So I am very much looking forward to this intriguing conversation today. And with that, I would like to pass over the baton to our today host, Anna Wojcik. Anna, over to you.
Thank you very much, Daniel, for this introduction. Good morning or good afternoon, everyone. It is my pleasure to present today's panelists. And we are very lucky because we have an exceptionally distinguished panelist with us who have demonstrated their commitment, their courage in the defense of the rule of law in Poland. So first, let us welcome Dariusz Mazur, who is the Undersecretary of State at the Ministry of Justice of Poland. And he's been working with the Minister of Justice, Adam Bodnar. Dariusz Mazur has served as a judge at the Regional Court in Krakow. And throughout the rule of law crisis, he's been relentless in his efforts to present the current situation of the Polish judiciary to the international community. His work has not been without personal cost, as he has faced numerous reprisals and disciplinary actions. So thank you for taking your time and to being today with us. Next, we are honored to have with us Judge Monika Frąckowiak, who is since recently the president of the court in Poznań. She's a member of the Associations of Judges Iustitia and the deputy president of MEDEL, the Associations of European Judges. She also has been a staunch defender of the rule of law, and she was one of the first judges in Poland that faced disciplinary harassment for their defense of judicial independence. And our third panelist is Małgorzata Szuleka, who is a member of the board of the Helsinki Foundation for Human Rights, a leading NGO in Poland dedicated to defending human rights and the rule of law. Małgorzata Szuleka is an attorney. She has worked as an advocacy officer, explaining to various stakeholders what are the critical stakes of the rule of law crisis in Poland. And she also co-authored and authored numerous important reports and studies on the crisis. So today we have this unique opportunity to hear your perspectives on the critical issue of the restoration of judicial independence in Poland. So let me just outline the format for the audience of today's discussion. So first, I would like to pose a few questions to Dariusz Mazur about his experiences at the Justice Ministry. And in the second part, I will invite Judge Frąckowiak and Małgorzata Szuleka to provide their comments and perspectives. And afterwards, Dariusz Mazur will have the opportunity to respond. And lastly, we will open the floor for a Q&A session. So I encourage the audience to ask your questions and share your comments in the chat. So without further ado, first question to Dariusz Mazur. So it's a simple question, general question. Could you please outline what are the key areas that you are working on that need to be changed and what are the foundations, the principles of the reform process that the ministry is currently engaged in? Unfortunately, we can't hear you. You're muted.
Okay, now it's correct. Okay. I said that we could end up with this question because the area which should be reformed, restored to the rule of law is so wide that describing of all problems could take hours, but I will try to tell about the main issues, the main problems which we face. As you probably all or most of you are aware, entire Polish system of judiciary and public prosecution has been captured during recent 8 years, both in systemic and in personal terms. Judicial self-government was, in terms of ordinary judiciary, the judicial self-government has been destroyed, and it was ended with famous, or rather infamous, Mazur Act from 2020. So one of our main goals is to restore judicial self-government, altogether with system of assessments of candidates for judges and candidates for judicial promotion, because it is the judicial self-government which played crucial role in this process, at the beginning of this process. Next thing which we have to restore, to rebuild, is the reform of system of appointment of court presidents. Currently, we deal with this problem in provisional way on the basis of recommendation of the Venice Commission. So when the term of office of the court president expires, or when we revoke the court president, we ask the local assembly of judges to present us at least 2 candidates for the position of the president, and then after their assessment, we appoint one of the person to the position of court president. But it is provisional solution. It should be resolved finally in a way of act regarding the organization of the court system. We have to reform the system of disciplinary proceedings against judges in organizational terms, from the bottom to the very top, including the system of appointment of disciplinary commissioners for judges and the system of appointment of disciplinary judges. We have also reinforced the right to the defense in disciplinary proceedings for judges. For example, there should be introduced ban of application of illegally gathered evidence, which is currently active. The next huge problem, and very controversial one, is to resolve the problem of neo-judges. I mean those judges who were nominated or promoted with participation of defectively shaped neo-national council of the judiciary. And in this field, we have 2 options which are crashing, 2 versions, 2 solutions. One is classical vetting procedure, which has been already applied in some European countries. And the second solution, proposed by the Association of Judges Iustitia, is sending judges illegally promoted with participation of illegal NCJ to the previous position, with possibility of their re-evaluation in the future competition procedure. In terms of National Council of the Judiciary, which has been captured in personal terms by appointing judges members who constitute majority of this body, by judges who were elected by the lower chamber of parliament instead of being elected by the judicial self-government. Of course, we want to come back to the solution which was active before 2018, which meant that it were judges who elected judges members of the National Council of the Judiciary, which is in accordance with Polish constitution and international standards. In terms of the Supreme Court, in which 2/3 of its composition consists of illegally appointed neo-judges, there are two main tasks. One is abolition of two newly created chambers, which are Chamber of Disciplinary Liability and Chamber of Extraordinary Control and Internal Affairs. And the second huge task is removal of neo-judges from the Supreme Court, because we all know that in the light of numerous judgments of European Court of Human Rights, each judgment delivered by neo-judge sitting in the Supreme Court is not a judgment delivered by independent and impartial tribunal established in accordance with law. And last but not least, we should make court proceedings more swift, more effective. We should introduce artificial intelligence. We should reform the system of the court workers. They should be paid more money. There should be more assistance of judges. So a lot of things have to be done, not only in terms of restoring of the rule of law in the field of judiciary, but also to make judiciary more effective to meet the challenges, the current challenges. It is of utmost importance because during recent 8 years, such activities were done at the very minimal level because everything was concentrated on capturing of courts, on taking personal control over the presidents of courts and stuff like that. And I think these are the most important areas in the fields of judiciary, because there are many other fields strictly connected with the field of judiciary, as restoring the independence of the Constitutional Tribunal, restoring the independence of the Public Prosecution Office as well. Thank you. That's in a very nutshell.
Thank you very much. Also, thank you for explaining that it's not only the restoration, but also the real reform, the increasing resilience. And the very practical question would be how it's done, like who is involved, what are the groups at the ministry, the committees at the ministry, and what is the schedule, the planned or provisional schedule of those changes?
Well, reforming is not easy due to a few factors. First is that everything is really screwed up to the large extent, and we have to rebuild many things almost from the ashes. On the other hand, we have to combine the process of reforms with conducting normal way of working of the Ministry of Justice. So we have to, the typical administration activities. So every decision concerning the professional life of each of Polish 10,000 judges passes by my desk and needs for my signature. So it's not easy to find time for reforming. Of course, another problem which we faced when we entered the Ministry of Justice was the fact that it was staffed with people strictly connected with the previous system, including quite a large number of judges who were seconded to the Ministry of Justice by the previous Ministry of Justice and who are suspected of being loyal in respect of previous Minister of Justice, and there are good grounds for such kind of suspicion. So we have to replace many people in the Ministry of Justice. Of course, we started to make this process. However, it has to be done in such a way that, on the other hand, we can't stop the works of the Ministry of Justice, because judges have to be seconded to different courts, to the different levels of courts by the Ministry of Justice. Judges have to go to retirement and so on and so on. So we have to combine the process of changes with process of sustaining of the normal activity of the ministry, which of course limits our powers in terms of swift changes. And of course, the ministry is only one of the actors in the field of regaining of the rule of law in Poland. There are many other actors like NGOs, like Parliament. One of the most important tasks is to prepare the amendments to existing acts of law and entirely new acts. We know that we will have to prepare entirely new act on the Supreme Court, entirely new act on the system of organization of ordinary courts, entirely new act on the prosecution office. So that's why we created a special task groups, how we can call it. There was, for example, created of the interdisciplinary commission regarding systemic changes in the Judicial and Public Prosecution Office, which includes people from NGOs which were involved in the fight for preserving of the rule of law in Poland, including Judicial Association. And there were also created special 4 legislative commissions, one regarding the system of courts and public prosecution office, another regarding reform of the civil law, another regarding reform of the criminal law, and the last regarding family law. And there were also created positions of representatives of the Ministry of Justice in some interdisciplinary areas which are especially important for preparing swift solutions. So there is, for example, representative of the Ministry of Justice, which is going to try to resolve the problem of frank loans in the civil proceedings, which is very, very sensitive from the social point of view, because the courts are overburdened with these kinds of civil actions regarding frank loans and credit.
Thank you. That indeed sounds like a big challenge, also on an organizational level, but we haven't yet discussed some broader ramifications. There are also political ramifications to what you can do. And in the action plan that was presented at the beginning of the year by Minister Bodnar, you included a list of a dozen of bills that should be enacted. However, there are also some fears that the president may veto it. So how is this reforming going when you have such pressures, also pressure from impatient civil society, from the public opinion?
It's a very accurate question because, as I said, many things were destroyed, many institutions were captured, and now there are I think 2 or 3 institutions which are mainly active in the field of combating the changes which we are going to introduce. I call these institutions anchors of autocracy because that's how they work. And I mean our current president, Mr. Andrzej Duda, who announced that he will veto any new law which will touch the position of neo-judges, because he believes he has a kind of divine prerogative. So it doesn't matter if judge was deficiently appointed or promoted. When he will be granted nomination by the president, then everything is healed and everything is divine and everything is correct. So that's the first huge anchor of autocracy, and it is very, very harmful, because the term of office of current president expires in May next year. So it's quite a long time. Another anchor of autocracy is Constitutional Tribunal, which has been captured during recent 8 years by the previous government ruled by Law and Justice Party. And almost all our activities regarding exchanging the presidents of courts by the previous Minister of Justice, regarding any kind of our activity in the field of ordinary judiciary, are challenged to the Constitutional Tribunal, which issues interim measures. These interim measures are beyond the capacity of the Constitutional Tribunal, so we don't recognize these interim measures. However, they are trying to do everything which they can to stop introducing any changes. And the third anchor of autocracy is current illegal National Council of the Judiciary, which is trying to stop revoking of politically loyal court presidents, which is trying to stop our activity. In these three anchors of autocracy strictly cooperate with each other. So, for example, the National Council of the Judiciary produces or lodges motions to the Constitutional Tribunal for interim measures in order to stop our actions. And of course, the President Duda can veto any legal act, and current governing majority in the parliament doesn't have qualified majority in order to reject presidential veto, which of course, and all these factors make the situation like that in fact the real legislative changes probably will be possible to introduce until after the end of office of President Duda. We prepared the draft law on the National Council of the Judiciary, but the presidential people announced that they will veto this act, even in the fact that Mr. Bodnar was ready even to accept the possibility of presence of the illegally appointed judges, the neo-judges in the future National Council of the Judiciary. And even in spite of such a far-reaching concession from the side of Minister of Justice, the people of President announced that they will that the President is still going to veto this legal act. So it shows that we will be forced to wait for serious legislative changes for another year, unfortunately, or at least it's very probable.
Thank you very much. Thank you. So now I will give floor to Judge Frąckowiak to ask her about the perspectives of judicial associations. Judicial associations have been immensely important in the defense of the rule of law, and I think that they have become household names and individual judges as well in Poland and abroad. So it's really important to see how judges perceive, of course I don't want to generalize, but like how the judges perceive the situation and what is the perspective of associations of judges that you are part of.
First of all, thank you for the invitation. I think this is a very important topic, especially in the light of what's happening in the whole Europe regarding judiciary. I need to stress out that I am a judge for 20 years now, and this is the very first time when I can say that with Minister of Justice, we are actually on the same side, and it's actually the first time when there is the real communication between judges and judicial associations with Minister of Justice. And We are very aware that it is very difficult to undo things and to restore rule of law in Poland again. And as Dariusz Mazur said, there are many former obstacles, and it is actually impossible at the moment to have the new law with the present president we have. And we also agree that we should concentrate not only on restoring rule of law, but on going forward, on modernizing the whole judicial system. I really welcome the decision of establishing the codification commissions and committees because it shows that there is, the idea of how the judiciary should look like in the future. However, I need to say that there are some judges who feel disappointment, and it is in the few fields. First of all, I really agree with the procedure which Adam Bodnar is using regarding the presidents of the courts. Actually, now I think the only way is to ask the assemblies of judges in particular courts to organize the assembly and to appoint few candidates, and then it should be up to the minister to appoint particular president, and it is already happening. But we need to have in mind that there are more than 700 presidents and vice presidents of courts in Poland. All of them were appointed by Zbigniew Ziobro, and now already like half of a year has passed with the new government, and there are like 115, as I remember correctly, the new presidents. And as I said, I really do understand that it cannot be very fast process. However, in some courts, there are still presidents who are, these presidents are judges who openly cooperated with this former government and violated all possible standards. So you can imagine that judges who work in this particular courts are quite disappointed. The crucial problem, and Dariusz Mazur already mentioned this, of course, is the Judicial Council. The good thing is that there are no new contests in the Judicial Council. However, the council as such is still operating. And there were some ideas and proposals, and also coming not only from judicial associations, but also some really distinguished lawyers, that implementing the verdicts delivered by European tribunals, the national authorities should and are obliged to do everything to block the activity of this institution. And as I said, they are still operating and causing, using euphemism problems in restoring rule of law in Poland. So this is another thing that, according to Judicial Association, should be done in different way. And there's also another issue with the disciplinary procedures, because this main general disciplinary commissioners appointed by Zbigniew Ziobro, they are actually still holding their positions. So the good thing is that Mr. Bodnar appointed some ad hoc disciplinary commissioners who take over the particular procedures, but the quite disappointing thing is that this three main disciplinary commissioners are still active, like Mr. Schap, Lasota, and Radzik. So expressing the voice of judiciary, I had to list these few areas in which there is kind of, let's say, disappointment among judges.
Thank you. It only shows how difficult this process is and how big expectations many people have, and rightly, and how perhaps tiresome it was to live under the previous system for so many years. So now we would like to just, turn the page and finally be able to work more efficiently, reform more swiftly. And in this process, the role of the NGOs is very important. The NGOs, various NGOs have been engaged in the defense of the rule of law for 8 years, including Helsinki Foundation for Human Rights. And today they are also active in debating, presenting proposals, commenting, criticizing some ideas. So we have a very lively debate in Poland. And I would like, Małgorzata, to ask you about the perspective of NGOs, or at least your NGO, because it's also difficult to generalize.
Thank you, Anna, and good morning and good afternoon to everyone. It's a real pleasure to be here today. There are several issues that you touched upon in your question, Anna, so I will try to structurize my answer, but if I'm missing anything, please feel free to interrupt me. So first of all, the one thing that requires a little bit adjustment is that the Helsinki Foundation has been doing the same thing since 1989. We basically a watchdog organization, and we document human rights violation, but we also try to keep those who are in power accountable to the constitutional or international standards. Of course, things are completely different right now because there are many of our former colleagues and friends joining the government, but well, I feel that in the last 6 months, we also showed that despite the political changes, we remain independent and yes, in some cases, quite critical to those proposed changes to that. Now, when it comes from my perspective on the process of the rule of law restoration, I would like just to build on what already Dariusz and Monika said. So first of all, we need to bear in mind that the government took power in very hostile political environment. I like the expression that Dariusz used, this anchors of autocracy. So to decipher it a little bit, it's the president who is on the collision course with the governing majority on a numerous of the rule of law oriented proposals, but it's also the Constitutional Tribunal, and there is also a lot of resistance coming from some of the institutions that were politically and personally captured during the last 8 years. However, with that being said, now what the process of the rule of law restoration requires, and this is the NGO perspective, and this is very NGO perspective because, mind my words, it's easier to be said than done. And I'm fully mindful of how difficult is the challenge that the new governing majority is facing. But I think that there are already some promising steps that have been undertaken, but there's still a lot to be done also in the parts of I would say, the intellectual and critical reflection of in terms of where we're going to want to be in the end of the process. So the first thing is that what we observe, and I think it's a step towards the good direction, is what already has been said. So, for example, the changing of the court's president. In general, in the system, the court president isn't the most important safeguard for the judges' independence, but as the last 8 years show, if the president wants to, they can really make judges' life miserable. And this has been documented in numerous reports we published in the last 8 years. The second thing is also the part of the politically influenced disciplinary proceedings. This practice was also seized, and that was something that was appreciated also by the European Commission and many other international actors. However, there are still some things that are missing in also the process of designing the rule of law restoration. And one thing that, from my perspective, in the entire action plan that the Ministry of Justice presented earlier this year is the part of the critical reflection on two things. So first of all, the political risks that might that remain a little bit undermined in the way how we see the process. And I'm not talking only about the president to the extreme willingness to block any sort of reforms. I'm also wondering what is the answer to the situation if someone from the law and justice camp wins the presidential election next year. So what is the scenario B for the ministry and for the entire community? So that's the first thing. And the second thing, what I'm missing is the proper thinking of the sequencing some of the steps that are being taken. And I think the discussion on the amendment to the National Council of Judiciary is a very good example of that, because I think that what I'm missing from the communication perspective, also from the government, is a bit of that. Why do we take in these particular steps, and how are we going to explain it to the base? Because don't get me wrong, but I also feel that the social emotions are completely in different place than it's rather the restoration of the rule of law. One of the issues that are highly debated right now among the public opinion is the situation on the Polish-Belarusian border, but rather in the terms of the security threat and not the humanitarian crisis that is ongoing there. And the second thing is also the accountability process of the former representatives of the former governing majority. So the rule of law restoration process becomes very much of a technical, legalistic issue that doesn't orchestrate the public imagination and attention. So to that, I think, and just coming back to my point on sequencing, I think it would be reasonable also not to map all those things we need to improve, but also in what kind of order this is going to be done, who is going to be on board in this process. So for example, the Venice Commission or the international institutions like the Monitoring Committee of the Council of Europe to that, or the Office of the Democratic Institutions and Human Rights. Ministry on numerous occasions communicated its willingness to cooperate with those institutions, and I think it's such a huge and promising change that the willingness is there. However, we need to be much more strategic into that approach, and to think in a particular, not only on what kind of actions we are going to do, but which action which will follow each other. So my final point on that would be, we should really, because right now in the public discussion, there's also many of those voices that Monika mentioned, is that criticizing the ministry for being too weak or too slow or too soft with some of those changes. I'm not joining the choir of that voices. I think that everything that could have been done in these circumstances is being done, but instead of drafting the new proposals, which may not be adopted within the next of the year, I would use the next year for the proper consultation process, proper feasibility studies, where we are in terms of the restoration of the rule of law, what would be the consequences of different solutions that are designed and that are proposed by numerous NGOs, by NGOs and also numerous stakeholders, and what would be our final end game? Because, and that would be my final point, is that I fear that the restoration of the rule of law may become somewhat overlooked in the years to come, especially given the very difficult political situation, because the one thing we tend to forget is that the new governing majority is a large coalition. And as we know from many political processes and also many other countries, is that usually the most difficult and technical problems like this one are being sacrificed to much more to a different problems that focus the daily attention of the public opinion.
Thank you very much, Małgorzata. And now let's give floor again to Dariusz Mazur, if you would like to respond to these comments. And I understand that this is a difficult setup for you because you are somehow reviewed, but I think still by a group of friendly initiative organizations and audience.
Yes. I'm not surprised that some judges are disappointed, because I'm one of the judges who faced all this pressure from the previous system. So I was targeted with 5 disciplinary proceedings. One is still pending. I'm waiting for judgment to be announced on 21st June. I understand well the position of judges who are persecuted and who would like to have reinstatement of rule of law, reinstatement of good court presidents as soon as possible. I've already told about some factors which made this job not that easy, not that quick, not that effective. Of course, I could name more of such factors. They are connected with state budget as well. They are connected with, which I have already mentioned, necessity to sustain normal way of administration by the Ministry of Justice. So, of course, the instant exchange of the staff of the ministry would be much more powerful, much more good-looking of terms in PR, but it could be equal to getting rid of baby together with a bath. So we can act in some areas gradually. In terms of court presidents, which was touched by Monika, that is true that we have 750 court presidents and vice presidents, and so far during recent 5 months, because we started doing that 5 months ago, we exchanged 115 of them. Today we exchange quite many new presidents in Warsaw and in the area of Rzeszów. It is going to be the largest action of exchanging of court presidents conducted in one day so far. But what is the real amount, the real number of court presidents which should be exchanged? Because it's not like that. In spite of the fact that all 700-something court presidents were appointed by the previous Minister of Justice, it's not like that all of them are absolutely politically loyal to the previous government, because this personal revolution was done mainly in the biggest courts, in the biggest cities. In the small court, provincial courts, especially in district courts, it was not like that those nominees were absolutely politically loyal and connected with the previous government. So the main factor to assess if the president was politically loyal to the previous government is the fact if the judge has signed the letter of support for illegally elected judicial members of current neo-national council of the judiciary, or if judge took part in a competition proceedings before the illegal National Council of the Judiciary. And if we look from that angle, it turns out that there are only 209 such court presidents. So from that point of view, we have exchanged a little more than 50% of those who should be exchanged, because they are suspected for being loyal, being politically loyal and appointed according to the key of political loyalty. In terms of making progress, it is also crucial to take under the consideration that those constant activities of these anchors of autocracy, on the one hand, they prevent us from taking currently huge legislative steps. On the other hand, this gives us more time in order to prepare well the future drafts of the future law. And I think that on the one hand, we should, as a Ministry of Justice, and also those organizations, NGOs, who want to restore the rule of law, on the other hand, to support those activities of the Ministry of Justice, of the Parliament, which help judiciary to survive the next year in relatively good health. One of these activities is revoking not proper court presidents. On the other hand, we should unite our forces in order to prepare the best possible draft law for the future. There is also another area of the activity of the Ministry of Justice, which I haven't mentioned so far, which I would call preparing pre-transitional amendments of law. For example, Polish system of secondment of judges to the higher courts was challenged before the European Court of Justice in 2021, and it was assessed as not transparent enough by the European Court of Justice. And the Ministry of Justice prepared a very narrow amendment to the Act on Organization of Ordinary Courts, which is just aimed to make this system of secondment of judges more transparent, which enables publication on the official website the reason of secondment of judges, in this way making it in conformity with requirements of the European Court of Justice. It's relatively small change, but it is very important for preserving the proper course of Polish judiciary. Why? Because if we assume that for the next 1.5 years, we probably wouldn't have properly working National Council of the Judiciary, then we face the situation in which there is no normal way of judicial promotion, and the judges who are in the highest ordinary courts and the Supreme Court are leaving the judiciary because those judges are the oldest ones. So that's why creating a system of ministerial secondment to the courts of higher instance seems to be crucial to preserve the right to the court for the citizens. The ministry also prepared a draft law which we call Anti-Mazur Act, which is going to erase these torts, judicial torts, which were introduced by the Mazur Act, which prevent judges from application of EU law. And we also prepared a draft law on the organization of ordinary courts, which restores the role of judicial self-government in this transitional period. And these draft laws doesn't directly touch the position of neo-judges, which is strongly defended by the President Duda. So there is a chance that he wouldn't veto these draft laws. That is another area of our activity, and I think that it is very important that, in spite of critics directed to the Ministry of Justice, which are natural, that such kinds of activities of the ministry shall be unequivocally supported by the pro-democratic entities. Thank you.
Thank you very much, Dariusz Mazur. And now it's time for the Q&A. So if the audience, members of the audience have questions, please post them in the chat. Yes, there is a question which I'm just reading out. Isn't there a risk that the government itself will fall into the same mistakes it seeks to avoid and may devise solutions that disrespect the rule of law or bend the law so as to bypass or circumvent the presidential veto? Wouldn't that legitimize the government itself? I'm thinking, for example, on the new practice of naming ad hoc disciplinary judges to ignore the decisions, of course, of the very arbitrary disciplinary chambers. So I believe that this is a question to Dariusz first. You are muted.
Is this question on the chat?
Yes, yes. It's a question from Almudena del Castillo.
Okay. I don't know. Okay.
So basically, is there a risk that the government will be...
Okay. I can see it. One moment. Fall into the same to avoid and my diverse so back to ignore the decision of the disciplinary. Okay, thank you very much for this question. In terms of ad hoc disciplinary commissioners, this is a kind of institution which was introduced by the previous government, this which was trying to ruin the independence of the judiciary. And the main aim of this institution was to enable the Ministry of Justice to start disciplinary proceedings against judges who try to act in defense of the rule of law, who try to speak up in the public. So I would say that in general shape, it wasn't the positive solution, and the intention of this solution was rather to undermine the independence of the judiciary. But the reality is like that our current government Ministry of Justice has in the possession those instruments which were introduced previously, and we have to find some provisional solution without changing the law because of announcement of the president of Poland that he will veto those solutions which in any aspect can touch the legal status of neo-judges. So yes, there is a kind of risk of abuse. Our answer is that firstly, we use the institution of ad hoc disciplinary commissioners. We use it so far only in a negative way. So not in order to instigate disciplinary proceedings against judges by the people appointed by the Ministry of Justice, but only to take over those disciplinary proceedings who were instigated against judges for application of EU law, for application of international standard, for speaking up in the public in defense of judiciary. So the task of these newly appointed disciplinary commissioners was so far not to instigate the disciplinary proceedings against judges, but rather to dismantle the groundless disciplinary proceedings instigated by central disciplinary commissioners appointed by previous Ministry of Justice. And of course, those decisions can be challenged to the disciplinary courts. And of course, we are trying to do that kind of activity in absolutely transparent way. So we announce any kind of taking over of the proceedings by ad hoc disciplinary commissioner on the official website on the Ministry of Justice. So the conclusion is that law in books, it's not the same as law in action. So you can use the knife in order to use butter with bread, or you can use the knife to kill someone. We are using the knife in order to prepare food, not to kill anyone.
And if I just may add one more sentence to that, because I think that the question really grasps very well the key problem we are having right now on, I would say, meta level, is that how to restore the rule of law without further violation of the rule of law. And I agree with what Minister Mazur said, that the appointment of the ad hoc commissioners is indeed in cases that were absolutely politicized, and they were groundless, because even if that case was had been directed to the disciplinary court, there's a very good chance that it would be discontinued, or that the judge would be acquitted, because there were the gravity of the charges were so weak in those cases. However, there are other, I would say, bumps in the road, not only this, that cause a lot of discussion and a lot of consideration whether certain models of restoration of the rule of law would be in fact in the line of international standards and the constitutional standards. And one of the problems here is, and the bone of contention, is the status of the so-called new judges. Because if we decide that they are not judges at all, or they were not effectively appointed judges, that would be quite questionable from the perspective of the constitutional and the international standards, and that would create a huge chaos also in practical implications. So my point is that no one has done it before. The illiberal rule books are already being written down. However, how to restore, how to roll back from the illiberal democracy to the full-fledged democracy, that's the huge problem.
Thank you very much. I'm aware that we still have some questions, but we only have 1 minute left because our panelists unfortunately need to go to another, they have other commitments as well. So I have copied the questions and perhaps we could pass them to the to our speakers and use any other opportunities to discuss them further. And I would like to say a big thank you to our wonderful panelists, to the audience, and also to the German Marshall Fund in this initiative to bring Polish discussions about restoring judicial independence closer to audiences in the United States and in Europe and across the world. So I'm giving back the floor for final remarks to Daniel.
Thank you so much, Anna. No final remarks on my end on the part of GMF. I also would like to say a big thank you for this highly informative and intriguing exchange. Ladies and gentlemen, thank you for being with us. And if you are interested in our Central Europe related work, please follow us on social media, and we would be delighted if we could welcome you again in one of our future events. Thank you all, and have a lovely afternoon. Goodbye.